Welcome to Claims and Sustains, a Seyfarth Government Contracts blog. I'm Zora Tajani, and I'm here with my co-host, Zach Jacobson. Today, we're talking about something deceptively simple. The U.S. Department of Defense wants to fix its own equipment. But that concept could have serious implications for a company's IP, data rights, and their revenue models.
That's right. Last year, Senator Warren and Representative Perez introduced bipartisan legislation in the House and Senate Armed Services Committees that would give DoD a stronger legal basis to obtain unlimited rights to use technical data and computer software necessary to conduct or contract out field and depot level maintenance. Last month, Senator Warren's office reported that the Senate's version has been incorporated into the upcoming NDAA, National Defense Authorization Act. If enacted, this legislation could limit contractors' ability to restrict the government's rights to use of technical data and computer software if the government considers that data or software necessary for maintenance, diagnostics, and repair without any regard for the contractor's intellectual property rights. So we're going to unpack what that means for your assertion tables, your business strategy, and future proposals.
And this issue is especially critical for startups whose valuation is in large part driven by their IP portfolio, by the rights that they've granted to that IP, and how they're monetizing that intellectual property. So as more and more startups look to enter into the world of defense innovation and contracting with the DoD, this coming right to repair requirement should be top of mind.
So let's start with the text. Both the House and the Senate bills use similar language. The key requirement is that the Secretary of Defense shall, the text doesn't indeed say shall, ensure all contracts, subcontracts, and other agreements for the procurement or modification of covered systems provide the government with sufficient rights to technical data and computer software required for depot and field level maintenance and repair. Now that this right to repair language has been incorporated into the Senate's version of the FY 2026 NDAA, there's real momentum in Congress behind this legislative change.
It's also worth noting that this applies not just to full systems, but subsystems, components, and modifications, which is a massive scope. So this is going to impact traditional defense contractors, the new defense primes, the traditional and non-traditional contractors of any size down the supply chain.
There's also a few noteworthy policy innovations. First, the bill emphasizes that the DoD must have fair and reasonable access to the materials required to perform the maintenance, diagnostics, and repair. The standard could serve as a measuring stick both for future protests and for contract disputes over data restrictions.
And as the House bill even requires that DoD obtain the part, tool, or information at prices, terms, and conditions that are otherwise determined by the U.S. government to be fair and reasonable.
And don't miss the language about the right to repair obstructions. See, the Senate bill requires the DoD to identify and address practices by contractors that obstruct the Defense Department's right to repair equipment. Now, the right to repair obstructions can include many things, such as withholding data, charging excessive fees, or imposing licensing terms that restrict repairs. These obstructions by these contractors will be reported to Congress in a publicly available report, leading to the potential consequence of a shaming of any contractors who attempt to impose restrictions on the Defense Department.
So if you've built your product's business model around maintenance as a driver of revenue or renewals, then you might want to consider whether that model, if it controls that repairing of the systems and how that is done, could soon be considered an obstruction as Zach just described.
And the legislation is going to require annual reporting to Congress by DoD to address how well the enforcement is going. If enacted, this legislation will likely lead to deviations to the DFAR and eventually new DFAR's requirements. These will find their ways into solicitations and contracts, contract modifications, as well as other transaction agreements in some form or another. Now, to understand what sufficient rights might mean, we need to revisit the DFAR's framework for data rights. When a contractor delivers technical data or computer software to the Department of Defense, the government's rights to use that technical deliverable depends on who funded the development of the item. This traditionally falls into 4 buckets. First, you have the unlimited rights bucket. Unlimited rights is for technical data or computer software developed exclusively by the government. This means that there are virtually no restrictions on the government's ability to use that data or computer software. The next level is government purpose rights. Government purpose rights applies to technical data or computer software that's funded both by the Defense Department and by the contractor, or we call mixed funding. This somewhat restricts the government's ability to use that data by restricting it to government purposes only. However, this does revert to unlimited rights after a duration, which is usually 5 years. Now, finally, you have limited rights or restricted rights. Limited rights in the case of technical data and restricted rights in the case of computer software. This is for deliverables that have been developed exclusively at private expense, and it limits the government's ability to use them primarily by restricting its ability to disclose it to third parties, with the exception of defense support contractors. I'll also add a note about commercial technical data and commercial computer software, which is treated somewhat differently. For commercial technical data, you essentially have commercial rights, which means that, similar to limited rights, the government is restricted in what it can do with that data. However, that restriction is very similar to what exists for limited rights, with the big change that disclosure to a support contractor requires written permission from the contractor delivering the data. Commercial computer software is in its own category altogether. Generally, the government receives the same rights that anyone who purchases software on the marketplace would receive to the extent permitted by law.
But there are important exceptions. The government is entitled to unlimited rights in certain categories regardless of funding. One is called OMIT, and that stands for Operations, Maintenance, Installation, and Training. And the other is Form, Fit, and Function Data, or FFF, or FFF. And this relates to the kinds of information, you can sort of see where that's going, around interoperability and also for support and maintenance. To emphasize the point, the government is entitled to unlimited rights even in the context of a commercial product or service. So as a reminder, what we just described is the current IP and data rights regime.
Exactly. And these carve-outs are often misunderstood. If you deliver a manual or interface documentation or the specifications necessary for maintenance or integration, the government is probably going to be entitled to unlimited rights. And this entitlement applies irrespective of how it was developed, privately or publicly, and whether it's commercial or non-commercial. Contractors who overassert protections or limited rights on data the government considers OMIT or form, fit, and function data are at risk for an assertions challenge or may even be found to be in breach. The new legislation will potentially expand the definitions of the categories of data that fall under OMIT and form, fit, and function.
And here's where the legislation sharpens things even further. So both bills propose updating the DFAR's data rights framework to explicitly reference, quote, maintenance, diagnosis, and repair, end quote. That's a significant change. So it's not then just about owning data for maintenance anymore, but it's really enabling that full life cycle of support. So think repair and diagnostic tools. So let's zoom out and connect the dots a little bit. The right to repair push that we've just been talking about fits into the broader DoD strategy around modular open systems approaches, so or MOSA, and you've likely heard about this. So MOSA is an is all about ensuring that the DoD can maintain, replace, upgrade, have interoperability among a system that was independently of the original developer. So that requires this modular design and access to those interface definitions and sustainment data. So this concept of DoD needing IP for repairs is also clear in the Intellectual Property Guidebook for DoD acquisitions that was published in April.
MOSA has legal backing. Under 10 U.S.C. 4401, MOSA is required in most major defense acquisitions. Various Defense Department guidances have integrated MOSA into its engineering and requirements development processes. This new legislation is clearly in sync with a policy push that has been inside the Defense Department for some time. Repair access is really just the latest front.
So to net this out, if you're bidding on a major program and ignoring MOSA or refusing to provide interface documentation, you're likely to be uncompetitive soon. And if you're relying on proprietary data to lock in sustainment revenue or drive renewals, then you may want to reconsider that approach.
The biggest immediate impact will be pressure on assertion tables and pre-award negotiations of rights. Expect more RFPs that include very specific identification of OMIT and form, fit, and function deliverables that include items for maintenance, diagnosis, and repair, requirements that grant broader licenses to items that the government deems necessary for maintenance, diagnosis, and repair, and perhaps more aggressive data rights validation challenges from the government against contractors who the government believes is obstructing their rights to data used for repair.
In longer term, this could affect your bottom line. So for primes, it could mean the end of exclusive sustainment models. For traditional subs, it means more scrutiny over how you justify asserting other than unlimited. And for commercial tech companies and startups, this potential impact on IP and business models could mean a slower, more cautious approach to contracting with the DoD.
But it's not all downside. I think contractors who can lean into this trend and differentiate themselves from the competition through transparency or some form of life cycle pricing can offer sustainment services as a standalone value proposition. And they can compete better than the competition on MOSA-aligned RFPs.
And turning to compliance and risk, the non-compliance has teeth. If this passes, DoD is required to report to Congress on the enforcement. And that means contractors who refuse to grant sufficient rights could face a variety of consequences: proposal rejection, negative CPARS ratings, breach or CDA claims if sustainment is blocked.
And also, improperly marking restrictions on OMIT or form, fit, and function data could result in data rights challenges. If you assert limited rights over something that the government believes, rightfully or wrongfully, they have unlimited rights to, this can lead to disputes. And if you've already delivered the data, if the government prevails in the dispute, it will assert unlimited rights and it will proceed accordingly.
And there's a reputational risk as well. No one wants to be the reason a $30 million platform sits idle because some manual or some tool that's needed sits behind a proprietary wall.
So here's what you can do now. The first thing you can do is audit your existing data rights assertions with an eye for your OMIT and form, fit, and function data, taking into account this new definition. Second, look at your assertions and determine whether or not you may be applying restrictions too broadly under the new regime. And then third, update your proposal templates in anticipation of these clause changes. And finally, engage with your technical teams to find out if there's a new way you could package your services or your products in such a way that either better protects your data or better sets forth the data items that will now be considered repair under this new rule regime.
And from the business side, one, consider reassessing your sustainment pricing, your maintenance and support, those assumptions. 2, evaluate if you can offer open data without losing value. And 3, you can position IP strategy as a competitive edge and not just a shield. You can redefine deliverables and assign those rights that the government will be looking for.
If you remember anything from this discussion, remember that right to repair is no longer a consumer issue. It's at the heart of defense acquisition reform, and it is being considered by Congress right now. And data rights are right now the key battleground.
So if you haven't looked at your assertion tables or interface documentation for a while, now's the time. There's an excellent opportunity to be proactive, to be strategic, and to use the right to repair as a value proposition to grow business with the DoD.
That's it for Claims and Sustains. Thank you for joining us. Feel free to subscribe on your favorite podcasting platform. Learn more at claimsandsustains.scifarthblogs.com.